Sanbonani greetings. How are you guys doing? I'm fine, I'm well, thanks guys. Okay, guys, in the previous video we dealt with the chapter 10 of the basic conditions of employment, but part A. So today we're going to be dealing, in this video, we're going to be dealing with part B and part C of chapter 10 of the basic conditions of employment. But before I get to it, guys, I just want to thank you guys for continuing to view the channel, for continuing subscribing to the channel. Please do subscribe. Those who have not yet subscribed, please do subscribe. At the bottom of this video, there's a subscribe option. Please click on it. So each time I release a video, then you get notified and you're able to engage and able to spread the message and the information. Thank you very much, guys. Okay, guys, let's get to the chapter 10 of the basic conditions of employment. Part B, legal proceedings. Consolidation of proceedings. A dispute concerning or contravention of this act may be instituted jointly with proceedings instituted by an employee under Part C of this chapter. 2. If an employee institutes proceedings for unfair dismissal, the labor court or the arbitrator hearing the matter may also determine any claim for an amount that is owing to that employee in terms of this act if A, the claim is referred in compliance with Section 191 of the Labor Relations Act 1995. B, the amount has not been owing to the employee for longer than 1 year. And C, no compliance order has been made. No other legal proceedings have been instituted to recover the amount. 3, a dispute concerning any amount that is owing to an employee as a result of a contravention of this act may be initiated jointly with a dispute instituted by that employee over the entitlement to severance pay in terms of Section 41 subsection 6. Payment of interest. An employer must pay interest on any amount due and payable in terms of the prescribed rate of interest rate Act 1975, Act number 55 of 1975, to any person to whom a payment should have been made. Very important. Proof of compliance. In any proceedings concerning a contravention of this act or any sectoral determination, it is for an employer A, to prove that a record maintained by or for that employer is valid and accurate. B, who has failed to keep any record required by this act that is relevant to those proceedings to prove compliance with any provision of this act. Jurisdiction of the labor court. 1. Subject to the Constitution and the jurisdiction of the Labor Appeal Court, and except where this act provides otherwise, the Labor Court has exclusive jurisdiction in respect of all matters in terms of this act, except in respect of an offense specified in sections 43, 44, 46, 48, 90, and 92. Number 2, the Labor Court may review the performance or purported performance of any function provided for in this act, any actor, omission, or any person, or any on ground that are permissible in law. Right. All right. The Labor Court, number 3, the Labor Court has concurrent jurisdiction with the civil courts to hear and determine any matter concerning a contract of employment, irrespective of whether any basic condition of employment constitutes a term of that contract. Number 4, subsection 1 does not prevent any person relying upon a provision of this act to establish that a basic condition of employment constitutes a term of a contract of employment in any proceedings in a civil court or an arbitration held in terms of an agreement. Number 5, if proceedings concerning any matter contemplated in terms of subsection 1 are instituted in a court that does not have jurisdiction in respect of that matter, that court may at any stage during proceedings refer the matter to the Labor Court. Part C, protection of employees against discrimination. Rights of employees. Number 1, every employee has the right to make a complaint to a trade union representative, a trade union official, or a labor inspector concerning any alleged failure or refusal by an employer to comply with this act. B, discuss his or her condition of employment with his or her fellow employees, his or her employer, or any other person. C, refuse to comply with an instruction that is contrary to this act and any sectoral determination. D, refuse to agree to any terms of condition of employment that is contrary to this act or any sectoral determination. E. Inspect any record kept in terms of this act that relates to the employment of that employee. F. Participate in proceedings in terms of this act. G. Request the trade union representative or a labor inspector to inspect any record kept in terms of this act and that relates to the employment of that employee. Number 2, every trade union representative has the right at the request of an employee to inspect any record kept in terms of this act that relates to the employment of that employee. Right. Protection of rights. Number 1, in this section, employee includes a former employee or an applicant for employment. Number 2, no person may discriminate against an employee for exercising a right conferred by this part, and no person may do or threaten to do any of the following. Require an employee not to exercise a right conferred by this part. B. Prevent an employee from exercising a right conferred by this part. Or C. Prejudice an employee because of a past, present, or anticipated failure or refusal to do anything that an employer may not lawfully permit or require an employee to do. Disclosure of information that the employee is lawfully entitled or required to give to another person. Or 3. Exercise of a right conferred by this part. Number 3, no person may favor or promise to favor an employee in exchange for the employee not exercising a right conferred by this part. However, nothing in this section precludes the parties to a dispute from concluding an agreement to settle the dispute. Right. Procedure for disputes. 1. If there is a dispute about the interpretation of or application of this part, any party to the dispute may refer the dispute in writing to A. A council if the parties to the dispute fall within the registered scope of that council, or B. the CCMA if no council has jurisdiction. 2. The party who refers a dispute must satisfy the council or the CCMA that a copy of the referral has been served on all the other parties to the dispute. 3. The council or the CCMA must attempt to resolve the dispute through conciliation. 4. If a dispute remains unresolved, any party to the dispute may refer it to the labor court for jurisdiction. For education. 5. In respect of a dispute in terms of this part, the relevant provisions of Part C of 20 Chapter 6 of the Labor Relations Act 1995 apply with the changes required by the context. Burden of proof. In any proceedings in terms of this part, A. An employee who alleges that a right of protection conferred by this part has been infringed must prove the facts of the conduct said to constitute an infringement. Right? B. The party who allegedly engaged in the conduct in question must then prove that the conduct did not infringe any provision of this part. All right, guys. That's the end of Chapter 10. We're doing Chapter 10 of the Basic Conditions of Employment, Part B and Part C, because Part A we did in the previous video. Okay? Thank you very much, guys. Then the next video will deal with Chapter 11 of the Basic Conditions of Employment. Guys, I still urge you guys to please share these videos on WhatsApp, Twitter, Facebook, whatever social media platform you're using. Please share these videos to ensure that information reaches as much wider audience as it possibly can, to inform and empower people. Right? Those who have not yet subscribed, please do subscribe to the channel, guys. Thank you very much, guys. Makanye.